subject to internal and regulatory processes. It is this non-fulfillment of the commitment after repeated assurances and continued engagement that forms the gravamen of the claim. Claimants allege that they relied upon the said MOUs and that the first defendant breached the terms by excluding them from the eventual recruitment exercise, thereby occasioning economic hardship and unjust treatment. This claim clearly falls within the contemplation of Section 254C(1)(a) and K of the Constitution, as it relates to a dispute over conditions of labor, engagement as casual staff, breach of understanding taken connected with employment, non-employment following specific recruitment promises, and claim for compensation grounded in unfair labor practice. The defendant's argument that there was no contract of service and hence no justiciable course of action is not supported by the modern approach to employment and labor relations adjudication under the Constitution. This court is not confined to formal contracts of employment, but is empowered to interrogate any labor-related transaction that gives rise to legal expectation or duty. In the case of Shena Security Company Limited, Afro Nigeria Limited. The citation is in the judgment. Therefore, the MOU are not constituting letters of employment may create enforceable expectations where they represent deliberate commitment and form the basis of a course of action in labor law. In view of the above analysis, this court finds that it has the requisite jurisdiction to entertain this suit as the claim arises from an employment-related dispute involving prior engagement, promise of employment, and alleged breach of same. Course of action is rooted in labor relations, falls squarely within the ambit of Section 254C(1)(a) and K of the 1999 Constitution as amended, and does not require proof of a formal contract of service before jurisdiction can be exercised. Also, the defendants contended that the time within which the claimants were to bring this action had expired. This court finds and holds that the continuing exclusion of claimants from recruitment in 2015, 2018, and again in 2023, as evidenced by Exhibit CW 34 to CW 36, shows that the course of action is a continuing injury. C.F. Young versus Mobi Producing Nigeria Limited. The citation of the Supreme Court judgment is in the judgment. In this case, the Supreme Court held that limitation does not apply to continuing wrongs. Accordingly, preliminary objection to jurisdiction fails and is hereby dismissed. Issue 2, whether the memorandum...
As the court pleases.
Issue 2, whether the memorandum of understanding, that's Exhibit CW 30, executed between the claimant and the first defendant, constitutes a legally binding and enforceable agreement. The crux of the claimant's case rests on Exhibit CW 30, that is, the Memorandum of Understanding, MOU, entered into between them and the first defendant, Petroleum Training Institute, PTI. The question that arises is whether this MOU is capable of giving rise to legally enforceable rights and obligations between the parties. In determining the enforceability of a memorandum of understanding, the courts have consistently held that not all MOUs amount to binding contracts. An MOU will only be enforceable where it contains the essential elements of a valid contract: offer, acceptance, consideration, intention to create legal relations, and certainty of terms. See BPS, Construction and Engineering Company Limited versus FCDA, where the Supreme Court stated, for a contract to exist in law, there must be an offer and an acceptance of that offer, together with a consideration and an intention to create legal relations. Where any of these essential ingredients is missing, there is no valid contract. Close of quote. In the present case, the MOU, that is Exhibit CW 30, was entered into on 25th July 2014. In content, its content, as deducted in evidence, shows that the PTI, acting through its management acknowledged the services rendered by the claimant as academic casual staff from 2007 to 2013. The MOU contained commitments from the first defendant to absorb the claimant into formal employment, subject to completion of certain employment formalities. Exhibit CW30 was further reaffirmed by Exhibit CW31, the follow-up correspondence dated 30th September 2015. This confirms that the first defendant did not treat Exhibit CW30 as a mere policy statement or intention, but acted upon it by initiating the processes for regularizing the employment of the claimant. The defendant's witness, that is DW1, during cross-examination, also admitted that the first defendant initiated recruitment exercise during the meetings with the claimants, communication, seen in Exhibit CW30 to CW35, and partial implementation of the MOU lends credence to the claimant's position that the MOU was not intended to be a mere statement of future intent, but rather a commitment to act in a certain way regarding employment regularization. Courts have heard that where parties have acted on a document or agreement, it may become binding, even if initially styled as an MOU. In Orient Bank Nigeria PLC versus Glante International Limited, the citation is in the judgment. The Court of Appeal heard where a party has acted upon the terms of an agreement, even if informally drawn, and incurred obligations or liabilities, equity will not allow the other party to go back on the agreement if doing so will amount to a fraud. It is therefore the finding of this court that Exhibit CW30 contains the essential elements of a valid contract. The parties are clearly identified. There was a mutual understanding, consideration, can be inferred from the work already done and accepted, and the intention to create legal relations is evident from the reaffirmation in Exhibit CW 31 and the continued engagement thereafter. The fact that the MOU was not labeled a contract of employment is immaterial, where the intent and subsequent conduct point to its contractual nature. First, defendant's failure to regularize the employment of the claimants as agreed under Exhibit CW 30 and its unilateral deviation from the commitments therein amounts to a breach of that agreement. Claimants are, therefore, entitled to seek redress from this honorable court. Accordingly, I resolve issue 2 in favor of the claimants. Issue 3, whether this suit discloses a reasonable course of action against the defendant. A course of action has been judicially defined as a combination of facts that, if proved, entitled the claimant to a legal remedy against the defendant. It comprises the wrongful act of the defendant and the injury or damage suffered by the claimant as a result. In Ibrahim versus Osim, the Supreme Court held that a course of action is the factual situation stated by the plaintiff, which, if substantiated, entitles him to a remedy against the defendant. Also, in Bello versus AG Oyo State, the citations are in the judgment, the court emphasized that the existence of a reasonable course of action depends on the facts disclosed in the originating processes, e.g., the complaint, statement of facts, etc. To determine whether a suit discloses a reasonable course of action, the court must confine itself to the claimant's originating process, excuse me, particularly the statement of facts and reliefs sought, without recourse to any defense or reply. In Dan Tata versus Muhammad, the Court of Appeal heard that the proper approach is to look at the statement of claim and see whether it discloses some course of action or raises some question fit to be decided by a judge. From the pleadings and evidence adduced by the parties in this suit, the following are alleged. A, that the defendants engaged the claimant as casual academic staff of the Petroleum Training Institute between 2007 and 2013. B, that a memorandum of understanding, Exhibit CW 30, was executed by the defendant in 2014, reaffirmed in 2015, acknowledging the claimant's services and promising to formalize their employment. C, that despite the claimant's rendering services for years, the defendant failed to fulfill terms for you and instead employed other persons in similar roles. D, that this alleged failure caused them hardship, economic loss, and denial of lawful expectation, which they are now seeking to redress through declaratory relief and compensation. These facts, if proved clearly, allege a wrongful omission on the part of the defendants and resultant injury to the claimant. Thus, the claimant's pleading disclose a reasonable course of action against the defendant, namely breach of an employment-related obligation, failure to act on representations made under the MOU, which is further litigated in issue 2. In such a case, it cannot be said that the suit is frivolous or that it lacks a legal foundation. Claimants have demonstrated that there are triable issues which merit the court's intervention. The defendants, in their final written address, argued that there was no formal contract of employment. The recruitment must follow federal civil service rules and public service processes. While this argument may be relevant at the merits stage, it does not affect whether the claimant have a reasonable course of action. The law is clear that so long as the facts disclosed in pleadings show an alleged legal wrong, the suit cannot be struck up. In Shell BP versus Onasan, the Supreme Court held that it is only when a pleading discloses a legal wrong or factual basis for a claim that the suit may be struck up for lack of course of action. This court finds and holds that the statement of facts discloses a reasonable course of action against the defendant. Claimants have alleged wrongful treatment and failure to act on representations made by the defendants, resulting in economic and professional harm. These are issues that call for judicial examination and cannot be dismissed at the threshold. As to whether claimants, issue 4, whether claimants are entitled to the reliefs sought. Having carefully examined the pleading, the documentary evidence, and the testimonies of witnesses, this court must now determine what reliefs, if any, are grantable to the claimants. Claimants in this suit seek declaratory reliefs regarding the existence and enforceability of the Memoranda of Understanding, Exhibit CW 30, CW 35, as well as monetary compensation for the services they rendered to the first defendant over several years. They also seek general damages and an order mandating the defendants to formalize their employment. As noted earlier in this judgment, under issues 2 and 3, this court finds that the Memorandum of Understanding, MOU, while not creating a formal contract of employment under extant public service rules, contains clear admissions by the first defendant of the services rendered by the claimant and expresses an intent to recognize and observe the claimant into the institution's formal structure upon meeting specific requirements. Claimants rendered verifiable services are supported by evidence and not refuted in material particulars by the defendants. However, claimants have not placed sufficient materials before the court to establish special damages, particularly the outstanding sum of $2,256,000 or $7,160,000 as debated in submission. No document or computation of salary arrears or pay slips was provided, and the pleadings lacked the necessary particularization required by law for such a claim. See NECA BBB Manufacturing Company Limited versus ACB Limited. The citation is in the judgment. It is tried that special damages must be strictly proved, and where the claimant fails to do so, the court cannot speculate or award such damages. As heard in Honorable versus Lawani, citation is in the judgment, and reaffirmed in Ishola versus SGB Nigeria Limited, citation in the judgment. Special damages must be specifically pleaded and strictly proved. Accordingly, this court cannot grant the claimant's claims for specific monetary compensation, having failed to meet the evidentiary threshold. However, the court finds that a modest award of general damages is appropriate, given the prolonged engagement of the claimant without formal recognition and the legitimate expectations created by the repeated affirmation of the MOU, in the MOU. Furthermore, in Berende versus UBN PLC, the Court of Appeal emphasized that general damages may be awarded where a claimant has suffered loss or inconveniences due to the defendant's wrongful act. Therefore, one is declared, is made, declaration is made that the first defendant engaged the services of the claimant and benefited from their evidence. An order awarding the sum of 12 million naira only to be paid by the first defendant to all the claimants jointly and severally for the inconvenience and inequitable denial of formal recognition for their service. 3, claimants are not entitled to special or specific damages having failed to strictly prove the same. 4. The claim for formalization of employment is refused, as this court cannot compare statutory employment contrary to lay down federal recruitment procedures. 5. Post-judgment interest at the rate of 10% per annum is awarded from the date of this judgment until the entire sum is fully liquidated. Parties are to bear their respective costs. This is the judgment of this court in this suit. That will be all. Court rests now.
Court. Thank you.